casebook, and then after that go through the Ucc Summary Sheet and go over the issues that we need to pay particular attention to, I think. And then next week, what we're going to do is I'll come in and just philosophize a little bit. And you can certainly answer questions. And I won't ask or discuss anything next week that will absolutely be a surprise. It's on the test or something. I don't want to do that. So I'm going to make sure that anything that I think of that could be on the test, we'll talk about this week. And then, like I said, next week I'll just answer questions and work something out with Mr. Hudson. And so if you want to turn your papers in on the 22nd, I think you can do that. You can check with him. And that way you've got at least a week to get ready for the test, because I think you need 1,200 pages. You need a little time to get ready. So obviously if you live close to here, come on in. So I'm not saying, but I probably, how far away you live and how best you can allocate your time. So I'm just trying to give you a little benefit of that. All right, well, this is a cumulative test. So we have 1,200 pages that we cover. Obviously, there are some sections that I specifically said I'm not going to ask you any questions about. We won't be in discussion over, and I'll remind you that as we go over it as well. A couple hints as we look at the material. One thing's for sure, just because I covered something on an exam the first time around doesn't mean I won't cover it again this time around. So some people try to do a shortcut on their studying, and they'll say, okay, well, I don't have to worry about what we studied the first semester because it was on the midterm. I just go right to second semester and focus on that. That's not a good idea. I mean, there are years where I'm given 60% of the tests from the first part of the year, especially because it's the first part of the year in a lot of ways that the bar examiners focus on. So that's that. All right, we start out with formation. Who leaves us up here like this? You won't say, is it Judge Smith? Is that who is it?
I think it's Mr. Davis.
Mr. Davis? Yeah, so that's not fair to people that come along. Right? What I would do, and I've told you this before, when I get ready to study for an examination is I start out with basically the index of material at the beginning of the book, if I'm going to make an outline. Now we skip around, so formation, which comes out in the kind of the middle of the book, is where we started. You've got the syllabus of how we started and where we started, other than those beginning cases. But what we focused on in the beginning was obviously offer and acceptance, and the definition of what an offer is. So even though it's been a long time since you studied that material, the offer and acceptance and the rules about offers still apply. So the offer is the explicit and clear and concise promise to be bound. Anything less than that, negotiations, maybe request for the other side to make an offer, but is something less than a commitment. So if we have the commitment, then at any time there is an acceptance that in common law mirrors the commitment, we have an agreement. We have a contract. So all those cases that we looked at, that we discussed, that we studied, defining offers, discussing sufficient acceptances, are obviously material that you're going to want to look at. And most of that material, with the exception of 2205, most of that material doesn't really concern the UCC. It's mostly pure common law material. 2205, which is a firm offer, really has a consideration aspect to it, as well as the offer aspect to it when we get to options. But probably with the exception of 2205 and 2207, which we'll talk about in a second. We'll certainly talk about it when we go through the UCC. The rest of it is just pure common law. And we're looking at common law rules. The key, though, in this test is to determine when the UCC applies and when the UCC doesn't apply. So that clearly is something in your little tickler, and that's the value, one of the values of that UCC summary sheet, is to learn through that. So, now, if there's a revocation before acceptance, there can't be an acceptance. If there is a counteroffer, that kills the offer. It becomes an offer, but that kills the offer. So all those rules, and I know it was on the midterm, all those rules that apply continue, obviously, to apply. So that material is material you need to look at. Even though it was on the midterm, even though it was on the that multi-state test I gave you way back in October or November, even though it was there, it still is material that you need to read and know and understand. Now, I've told you that the bar examiners focus greatly on Battle of the Forms, 2207. One, you need to know when that applies. good scenario. And when it doesn't apply in a non-UCC scenario. Then you need to know 2207 well enough to understand that in most cases, especially if it's a true battle of the forms, there's not an acceptance of an offer or an acceptance, but it's that third ground where the parties form a contract where there's an agreement between the offer and acceptance, and where they don't, the UCC gap filler provisions apply. And you did a good job on that last year, but you've got to look at that material again this year on that. Mistake was something I really didn't get into much on the midterm, but unilateral and mutual mistake clearly is important. You need to know the difference between unilateral and mutual mistake. Mutual mistake is a basis for rescission always. Unilateral mistake, though, the mistaken party is only going to get recovery and rescission if the unmistaken party participated one way or the other in the mistake. Either caused the mistake or knew the other party was mistaken and didn't do anything about that. So, mistake, all those capacity issues that we looked at and discussed are matters that I would say I might very well ask about on a final exam. Let's talk a little bit about statute of frauds. Just some guidance, some hints on statute of frauds. And really leads over to parole evidence. On a fact pattern, if I spend a lot of time and effort talking about a oral agreement that was never reduced to writing, or I talk about a written agreement after which the parties maybe modified it, any emphasis I make on a writing is a clue and a cue for you to ask yourself, you got this Ucc Summary Sheet, to ask yourself, is it applicable to the statute of frauds here? What type of contracts do the statute of frauds apply to? And we'll talk about parole evidence in a minute. But statute of frauds, obviously if it's a land contract, if it's a contract incapable of being completed within a year, that's probably the only two types of examples I'll give you, but you should be cued in to that. So look for that in writing, and that should be something that's a trigger in your mind, because I'll do that, and I'll specify. So the minute you see in a written contract where the parties negotiated and then reduced it to writing, whatever terminology I use, whatever it is, that should be a clue to you to start asking yourself, does the statute of frauds apply? So the more difficult things about the statute of fraud is not so much when do they apply, but what constitutes memorandum, Crabtree case, what constitutes a memorandum, what defense do you have to the statute of frauds. If it's goods, the defenses that you have are specially manufactured goods, or a confirming memorandum that's not responded to, estoppel, full performance, all that material around page 400 to 415 that deals with exceptions to the statute. And then, of course, what writing does comply with the statute. All right. Getting back to mistake, we have that whole series of defenses. Capacity, either age, lack of capacity, or mental infirmity. We have, besides mistake, we have fraud, which is the material misrepresentation of a fact. And then we also have fraud from failure to disclose. So all that material on fraud and the various types of fraud. I think that Hill versus Jones case, that termite case, is a great case for discussing when there's a failure to disclose, where there should have been disclosure, misrepresentations, all of that material. Again, it'll be clear, it'll be just out there. I won't hide it. I'll make sure if fraud has been committed, where there's a misrepresentation, that it's plainly and boldly in the fact pattern that you do. Duress and undue influence. It's doubtful that I would give you a fact pattern dealing with that, just because just so clear that's material that you should not have an issue with. I doubt I would ever test you on it, but I wouldn't spend a lot of time on it. Unconscionability, well, in the past, I would have said the same thing, that I wouldn't spend a lot of time on it. But now, I suspect in one way or the other, I will have an unconscionability fact pattern of some sort. It could be on multi-state, could be in a short answer question, it could be in an absolute full question. Remember, procedural and substantive unconscionability. You need both. So, unconscionability, I certainly would study, spend some time on it. And I understand that unconscionability is sort of nebulous, but it certainly is there. And I think where it's going to be prevalent in a fact pattern, maybe. So I don't make these tests up until right before the final. In this day and age, when we have these unfair contracts that either mandate arbitration or maybe have some sort of release or waiver in them of rights, most likely that will be a 2207 fact pattern. But I might not even catch it. Generally, I'll add to that fact pattern a provision or formation provision or fact pattern that one could look at and say, well, the contract, the subsequent contract was unfair. The way the contract was forced upon one of the parties was unfair. So the term is unfair, the contract term is unfair, and the way the contract was created was unfair. Just looking for you to just say something about unconscionability. And that very well adds points to the all right. Illegality in public policy. Page 556. Important. Very important. And the reason it's important is it kind of comes back to just exactly what I was describing in unconscionability. And that is illegality. I'm not going to give you a flat illegality question. I can almost promise you I'm not going to have a fact pattern where someone says, if you give me $100,000, I'll treat it in a legal way. I'm just not going to give it. Again, that's just very obvious. I'm not going to give you an illegality fact pattern. But what I might give you, very likely, well, might give you, is a fact pattern where the agreement is over something that involves public policy. Could give you a fact pattern dealing with the purchase or sale of weapons in the context that it may be against the public policy of the state or the city to allow this type of contract to go forward, not based on an actual physical law violation, but the public policy of the community. An example of that might be that the policy of the community prohibits, as an actual law, a location of what it does for alcohol, maybe the location of a gun store within 2 blocks of the school, or 600 yards of the school. I forget what the beer laws would provide. But some sort of lease agreement that would allow the sale of something that could be construed a weapon might not be strictly illegal, but it would violate the public policy of the community, and so you might be able to get on the contract because of that. I'm also thinking about the various health issues that might be out there. I don't know what my fact pattern is, but again, if I were to construe that type of fact pattern, what I would do to make up that type of fact pattern, I would clearly emphasize whatever it is that the community supported some type of marriage provision. And then the contract itself was something that wasn't illegal, but clearly it was different than what the public policy of the community is. And I might add something like that. So public policy to me is important, and especially all those restricted covenant cases that we talked about. But I doubt seriously, I'm just trying to be candid with you, I doubt seriously that I would, that gives the example of the lottery tickets in states where data management versus green on page 582 not repeat. Or I might have a provision dealing with a radio station that dealt with gambling. Would not be illegal, but if the contract dealt with the radio station, and the radio station sole purpose was to air horse racing or betting on gambling, I probably would state, something in there which made it clear that it was a law of a particular state that you could not do this. The question is, the purpose of the radio station, or at least the program of the radio station, was to foster gambling or foster something else that was illegal. With the enforcement of that contract involved public policy. So illegality in public policy, I do think is important, and we sort of went over that pretty quickly. All right, let's get to consideration, okay? This year has been a good year for consideration. Okay? And fortunately, it was successful with my consideration arguments. And I really attribute that to all my teaching all these years. So that finally my students have become judges, and even my students, even judges that aren't my students, by osmosis, have really learned consideration. So I would have to say the judges in this state are the best in the United States. In fact, wasn't there some article in some newspaper where they were bragging about our judges and our judicial, somebody discussed that with me, how great our judges are, and I don't know how they do it, how they rank it. Maybe it's reading the opinions from our appellate courts. Don't know how it goes, but our judges are considered to be in the very top of all the states in the country, which I think is great. And I take some. Osmosis. I didn't teach all of them, or even most of them. Osmosis works. So as my students have gone out and multiplied by osmosis. So consideration. I know we emphasized it a lot, but it's been baseball's been good to me. Consideration has been good to me this year. So I can't rule out that we won't have some discussion of consideration. And I think this class did a great job on the midterm. I mean, I think it was almost 100% on this midterm on consideration. So I know you know it, so I just may throw it in there, just to give you something easy. And usually consideration is the hardest material that we deal with. So, but consideration, promissory estoppel is material that you need to know. You need to know. I don't need to go over it with you again. I've drummed it in your head hard enough. But you need to know what is consideration, and as you demonstrated in the midterm, when you don't have consideration, when there isn't bargain for exchange. So good job on the midterm, good job in consideration, but it very well could wind up on the midterm. Oh, excuse me, the final examination. All right, so that pretty well covers the first half of the year, brought us up to about January, and then we got into, as I said, the harder material. And so let's talk about the harder material because it will be on the exam. No question about it. We're going to have lots of performance issues on the exam. Before we get to the actual conditions, we started out with parole evidence and interpretation. And we focused on, and this will be on the final, the four-corner rule. And that fact pattern will clearly show negotiations up here, agreements up here. Like I said, I hate the term parole evidence rule because it's really extrinsic evidence rule. So you'll have exchanges of emails. You'll have phone conversations. You'll have lots of chatter up here. And then you'll have a document. And most likely the document will be very specific and say, this document incorporates and includes all agreements between the parties. A merger provision, okay? Integration provision. So all of this gets integrated into this document. And then there'll be a breach of this document, and the focus will be on the but you said, but you agreed to terms that doesn't make its way into this. Can't promise there'll be a question like that, but I think there probably will be a question like that. Okay? Very clear, very concise, very specific. Now, the question may go beyond it. The question may just deal strictly with the parole evidence rule. But the parole evidence rule is there. Could you make an argument that the agreement is collateral? Okay. Kind of the Mitchell versus Lathe argument? Fine. For me, what's important is for you to identify it, to know that it's a parole evidence scenario, that this earlier or contemporaneous chatter is not relevant or material, more importantly, is not material, because this is the agreement. In all those cases that deal with that, this is the agreement. The UCC version is 472-202, and very important, 472-202, very important. And I told you, knowing Mitchell versus Lathe, knowing the 2202 cases is probably all you really need to know. But you need to focus on this in your study on 2202 and on Mitchell versus Lathe, because it will be there. Every contract, every piece of contract litigation, wherever, whatever's involved, if it deals with a writing, you will have a parole evidence issue. I promise you. So, very important to know parole evidence.
Say the case name again, please.
Mitchell versus Lathe.
Okay.
Now, in this chapter or section, and I think it's been changed a little bit, and I can understand why the authors did it. In the section dealing with parole evidence, there clearly was an emphasis to also make you folks think about other ways this kind of chatter can get into evidence, into trial. So we have discussions about if you allege fraud, this is a way this can be introduced. Fraud, mistake, misrepresentation. Any kind of allegations about that is another way this evidence can be introduced. not the very terms of the agreement, but it's a way you can get it at trial introduced. And more importantly, and most importantly, if this is ambiguous. If there is an ambiguity in the agreement, then for purposes of interpreting the agreement, you can introduce extrinsic parole evidence, these things up here. So go back and reread that material and familiarize yourself with that material. Parole evidence, very important. And again, parole evidence, there's a way to flag that. I'm sure I told you when we were first discussing it. The way to flag it is a written agreement containing a clause that says this is the integrated discussions of the clients, or this is the agreement of the clients that can't be changed or modified except in writing. Some sort of language that lets you know that this is the final agreement. This is the final document. I'll have that in the document. Now, as we saw in Mitchell versus Lathe, that's on page 613, by the way. As we saw in Mitchell versus Lathe, he doesn't absolutely have to have that clause in there, but certainly when you have that clause in there, it's easier to find an integration. So that section, which I guess is from 616 to about 660, very important section. Very important section. Because that helps us determine what it is we're dealing with. Reglement on interpretation, 645. After we finish with that, we dealt with good faith. Now, I will grant you that good faith in that context, page 669, is just sort of academic language. When we look at Centronics, because that's the first case in 671, defining what good faith is, and quote, it's the honest expectation of parties. We have UCC definition of good faith. We have the duty of good faith, Article 1, 304. It's not so much what is or what isn't good faith, it's how good faith is used that could find its way onto the exam. So we'll go back over the ways that good faith can be used. And this goes back to the first part of the year where we look at good faith. One, consideration. Does anybody remember how good faith interfaces with consideration? But when does good faith come up in a consideration scenario?
Is it when they bargain with each other that they bargain into?
Well, that's in formation. It's not so much there.
When they say they're going to do something like they're going to try to get financing for a loan, they have to actually try to get financing.
And what is that area called? What type of contract might that be? Somebody said illusory? Somebody said mutuality? Okay. So, mutuality, illusory, Graham versus Walker, that is, I'll buy the house if I can get financing. Or I'll buy the house if I feel like it. Well, if I feel like it, your honest expectation is they may or may not buy it. There's no consideration there. But if it's I'll buy it if I can get financing, good faith, honest expectation of the parties requires them to do what? Attempt to get financing. And Grimm versus Walker was that sort of nebulous area where the buyer said, I'll buy it unless some unforeseen reason comes up and I don't buy it. So the honest expectation of the parties, the court there said, was illusory, that they didn't really have to buy it. But if you say, I'll buy it if my board approves it, I'll buy it after I've done due diligence, I'll buy it if I can get financing, that requires you to go out and take affirmative steps to do that. And if you don't do that, or you lie on your application to make sure you don't qualify, guess what? It's bad faith, you know. It's bad faith. All right, so consideration was the first time. The second time that we see it in the context of prevention of performance. You literally do something that prevents the other party from performing, so that the other party is going to lay a foundation, but first you have to you have to do something so they can lay the foundation. You do nothing. Or we had another case where the one party didn't heat up the ovens so that the other party could toast its bread. I mean, it's one party to an agreement who agrees to do something, doesn't perform. That's bad faith. That's kind of clear. Don't think I'd give that easy of, frankly, fact pattern. Third way, and this is the hardest, exercise of discretion in a condition. So, a bank that lends money has a provision that they can call the loan if the other party is not performing in an adequate way, or if the bank feels insecure about its position or about its collateral. That's one example. We talked about it. The courts have said the bank has to use good faith in exercising its discretion to foreclose or to call a loan. Same thing with a franchisor or lessor terminating a lease if it feels like the tenant is not keeping the property clean or is not living up to its commitment. That's an exercise of a discretion or condition that's given to the landlord. The landlord has to exercise that discretion in good faith. And you recall in Centronics, there was a provision, what we call a basket, that the seller insisted it should get at least part of its dollars of the sale of its business back, even though the mediation and arbitration process wasn't finished. And they said it was bad faith on the other party's part not to let them get the money. And Justice Souter said, no, just the opposite. The honest expectation of the parties was, you're going to wait until everything happens, then the money gets split. So these are the three ways that we look at good faith. So it's not really the definition of good faith, it's more when does good faith come to play. When you might see it, you might see it here, you might see it here. Good faith is also important, as we said. It turns a illusory contract into a definitive contract. We had the chipping, I forgot about that, the chipping case where they failed to chip. All right. Another area that's a condition area that I want to remind everybody about, go over again, could very well find its way into the final examination, deals with the pre-existing duty rule and modification of contracts. 2209. And good faith plays a role in this because you'll recall, and again, easy fact pattern, easy way to flag it. Usually there is, quote, a duress aspect in it. Did you have contract number one, and then either the paying party or the performing party says, I want to be paid more for what I agreed to do, the fisherman, or I want to do less for what you're paying me, the performing party. Either way, somebody or the paying party says, I'm going to pay you less, but you're going to do the same amount of work. That fact pattern invariably, always, requires a pre-existing duty rule analysis. Because if one party is doing the exact same thing they had agreed to do in the first contract, and the other party is either doing more or less, then there's no consideration for the second contract. Remember that? And usually it's both lack of consideration because it's pre-existing and duress. Usually this is born of both things. The UCC changes this. That's what you got to know. It's important. The UCC changes this in 2209 because it does not require consideration when you create that second contract. But if duress is involved, then most likely there's been what? Bad faith in the procurement of the modified contract. Lack of consideration. So that's what that discussion's about on page 709, and that brings you back to consideration. So this type of fact pattern allows me to work on consideration and good faith, if I were to do that. So that's an area that I probably would spend some time looking at. warranty section is a short section. I certainly would know limitations of warranties, applied warranties. I think I focus on page 736 to 740, 736 to 740. Might wake up and decide to give you something about applied warranties or the disclaimer of an express warranty, which is not effective. 736 to 740. I think I'd look at that, become familiar with that. We'll talk about it again when we get to the UCC sections, but I think I'd look at that. All right, page 740, conditions. I don't like conditions, you don't like conditions. Do we have any math teachers in here? Anybody that's ever taught math or is a mathematician? Nobody's a mathematician? A little bit of mathematician? I mean, I can look. Anybody major in math? Nobody in this whole class major in math. Anybody like math? You major in math? Well, let me ask you a question. Pi r squared, pi being 3.14. Is a way you discover the circumference of the circle, correct? How do you determine the surface of the circle? Is it pi d?
Pi divided by 4724. Pi divided by 4724 with the cosine of 4.6.
So what you're saying is,
I have no idea.
nobody can help me with that? How do you determine the surface of the circle?
That's pretty funny.
Pi d is the surface of the circle. So you multiply 3.14 times the diameter, and not even squared. You just, so if the diameter is 20 feet, right? And you multiply that times 3.14, that's it, right?
That's the area of the circle.
So if 20 feet is the diameter, if you multiply 3.14 times it, then that's just 60 feet. That's not possible. Huh?
Thursday has family circle.
Math.com says that it's 4 pi r squared.
4 pi r squared. If sphere is 4 pi r squared, because the circle is pi r squared.
That's the surface area of the sphere.
Yeah.
I want the surface area of a circle.
Pi r squared.
Pi r squared. So you multiply 3 times, that's 40, okay, right? 20 squared is 40. No, it's 400. So 3
That's the diameter, not the radius.
Yeah, that's the
That's the diameter. It'd be 100.
So 10.
Radius is
It'd be 100. Radius is 1/2 the diameter.
So it's 10.
It'd be 10 times 10. It'd be 100.
What would it be?
3 times 100.
3 times 100.
Whoa.
It'd be 300.
Yes. That
300.
We regress.
So it'd be 300, right?
Right.
300 cubic feet? Is that
Square.
squared.
300 square feet? Okay. And if it rained 2 inches, how much water would that be?
That would be 600 square inches. No. No. That would be 7,200 square inches.
7,200 square inches. If you translated 7,200 square inches into into gallons, can you do that? Is that
Into gallons? Are you serious? Shit, I can't do that, man.
what would that still be math, right?
You gotta figure out how much 72 square inches weighs and divide by 8.8 pounds per gallon.
Do that during the class, okay?
Yeah, I
sister?
can't.
You can't do that?
No. I gotta take too many notes.
What math would we be using there? Would be algebra?
Geometry.
Would that be geometry? I'd like to tell you the point is conditions. I don't know the bad feet, but I can also tell you I got a pond that kind of leaks. I'm trying to figure out how much water can I put in that pond every few days during the summer, and is it financially feasible to do? The point I'm trying to make is conditions can be extremely complicated. They require lots of steps to make a determination. But we learn conditions in a very easy way when we saw the Dove case, Rosario case. And that is, be it an agreed event to happen, or a factual event. Time, date, atmosphere. Either way, it's the expectation of the parties that govern performance. And that's the easy way to deal with it. Because if you have pi, and you can use pi in every circumstance, then you don't have to examine each and every circumstance. And that, quote, pi is the expectation of parties. If performance of the agreed event is the consideration of the contract, then it's material because the parties expected that. So everybody goes crazy over, well, is it just a promise? The failure of which does not result in a forfeiture because the other party still has to perform, may get damages for breach of contract because the pipe was ready pipe instead of stand-home pipe. Or is it in fact the consideration for the agreement? That all depends on the expectation of the parties. So when you get a fact pattern from me dealing with a condition precedent, but not labeled a condition precedent, and you're trying to say, I can't figure this out. It's just It's like what he's doing for me right now. I just can't figure it out. Just too many moving parts. You start with, what did the parties expect? Did they expect the white car, the silver feather, him showing up every day and never being sick? Did they expect that to be a consideration for the overall agreement? If that's what the expectation of the parties was, based on reading the contract, it's a condition precedent. And a condition precedent must be performed. If it's not performed, the paying party or the other party's obligation is discharged. Same thing with a factual event, and this also goes to impossibility. If a time is a material part of the agreement, cargo must be shipped on this date. The payment must be made on this date. The house must be sold on this date. Then that's material provision, failure of which is a forfeiture. And the way you make that determination is to look at the expectation of the parties, and you have to look at the contract. Oral or written, you have to look at the contract. Now, the hard cases are dealing with these tweeners, where it's a real estate agent who is to be paid when the property sells. Not if. If it's clear that the expectation of the parties is it's an agreed event that must occur. But when. The engineer that designed the graphite mine is to be paid when the building is finished. Neither one of those things happen, but he still due the payment at a reasonable time. So the easiest way to look, and believe me, kind of like Einstein here, it took me forever to kind of figure this out. That instead of looking at each individual fact pattern separately, if you look at each fact pattern with what do the parties expect, determines if it's a condition or not. It's a lot easier. What did the parties really expect in Jacobson Young versus Kent? Did they really expect this pipe had to be that specific type of pipe? Or was all the pipe basically the same? And that provision was a promise, and so you get in the way of damages the difference in value, if any, between the two. So, I know it's hard. Go back, rethink those cases, relook at those cases with that idea in mind. Of course, we started with the, with Mark Dove versus Roseacre. And again, nothing in this wonderful case is labeled a condition precedent. If I label something in a fact pattern as a condition precedent and it doesn't occur, that's going to be easy for you. I might do that. If I do that, you need to know that I'm probably focusing on you then coming up with an exception or a way around that forfeiture. Or I might just give you a fact pattern with a written contract that has promises and potentially conditions precedent all inside it. And you've got to make a determination which it is. And you start with this, and you use that expectation of the parties as kind of pi. So that pi, the number pi, it's the factor that you use. You use this as a factor in making the determination as to whether or not you have a true condition precedent or you simply have a promise. Does that help? Yes.
Question. You said that the real estate agent is to be paid if the property sells you.
That's, to me, the expectation of the parties there, if the expectation is, if means it occurs or doesn't occur. That promise is a condition precedent. Okay. Now you're asking, why didn't he do this before we started studying conditions? Because I just thought of it tonight. That's why this room is a laboratory. Somebody needs to email this to me, because this is like E equals MC squared. Because it's the biggest problem that you have with condition, with all of contracts, is trying to make it, because the way these academics write it, like Judge Posner, it's just all up in the sky. It's really common sense. Some of your best judges just use common sense looking at, well, let's see, what did the parties mean when they said Reading pipe or Stanhope pipe? Sometimes you can't figure it out. You just comes to. All right, so Rose, Dove versus Roseacre is one of those examples. Again, in Carter's claim. In Carter's claim, a lot of those things look the same, but at least in Carter's claim, they're labeled. One's labeled a condition precedent, one's labeled a warranty. Breach of warranty, you get damages, but no forfeiture. So when the breach of warranty occurs, you get money. If it's a condition precedent, you can walk away from the deal, but if you don't walk away from the deal, you don't get damages on the other side of it. So, just got to go. I mean, it's just material you got to read and think about. Once you get over, anybody can think of anything, right? Should have been a police officer who could have solved all those cases, y'all. I'll be able to figure out. Once you determine something is a condition precedent, right? And there's a failure of a condition precedent, forfeiture. What's the great rule? If you don't complete the condition, the other party doesn't have to pay you. It's the great rule on conditions. But that creates a forfeiture. So what we do, and you're going to have to deal with next week, is what we do is we look at ways around the forfeiture, around the conditions precedent. So first you have to recognize it's a condition case. I might put it in the agreement if I'm feeling kind. If I don't put it in the agreement, then you got to figure out it's a condition precedent that doesn't occur. If it doesn't occur, what are ways that the poor person that didn't complete the condition precedent still can get paid? Well, substantial performance is the most usual one, right? Good faith performance. Can't be bad faith. Can't be the wrong roof color. It's got to be good faith performance, like we saw in Jacobson Young versus King. Okay? If that in fact was a condition precedent. If it was a condition precedent, if it was just a promise, then you don't have to worry about it. So, substantial performance. Okay? Waiver, that is what we saw in Ray Carter's claim, condition precedent, balance sheet had to be the same, don't care, we're going to close, the condition gets waived. And you have the same kind of scenario in breach. Modification of the agreement. But if you modify the agreement, what do you have to have?
Consideration.
You have to have consideration because it's a subsequent agreement. And then unjust enrichment. So go through, and we talked about that, go through all those scenarios and you deal with ways around the condition precedent. Now, be it a condition precedent or be it a promise, events that the parties expect to happen or facts that the parties expect to exist can, through no fault of the parties, not occur. And that was the practicability of performance. So, give you a fact pattern. Could be taking coal out of the ground, could be any number of facts. But whatever those facts are, either there was a subsequent fire that burned down the structure, or when you're trying to take coal out of the ground, there's water there, or it could be an illegal, you could have a contract to buy or sell something which later becomes illegal. All these different occurrences that are not assumed that they will occur by the parties do occur, then performance is excused. So they call it changed circumstances. It starts on about page 799. Practicability, frustration of purpose. All of those scenarios, generally speaking, pretty easy on those. Generally, it's always going to be a subsequent event that occurs that makes it impossible for the contract to take place. Now, if it deals with the sale of goods, it's 2615. But this is one area that common law and the UCC are pretty sympathetic because you get the same result on impracticability of performance. And then we got into what we studied for the last few weeks, which is breach. Breach and anticipatory breach. Breach is simple. Breach is when time for performance is to occur, the parties don't perform. Breach of contract. The more difficult scenario is anticipatory breach or repudiation, where the party, one of the parties in advance of performance indicates or does an act that indicates they're not going to perform. At common law, the victim of that anticipatory breach can either accept the breach, sue, move on, or demand performance and wait until time for performance. Under the UCC 2-610, same two choices, except they can only wait for a commercially reasonable time. Very, very important distinction. Very important distinction. And after that, we got into damages, and I'm not going to review damages with you because we have just spent the last few weeks on that. Probably won't ask you the damages question. Might, but I told you specifically what areas I would if I did. Equitable remedies, need to know the general rules about equitable remedies and if the courts like and award damages much easier than they do equitable remedies. All right, UCC Summary Sheet. We'll go back over this again. As long as I can read it, I don't care what you do. This is the only thing you can bring to the test. By the way, you're going to need blue books if you're going to handbook. How many of you expect to use exam 4? Oh, excellent. Excellent. It's the most technologically advanced class I've ever had. So you can take this, do with it as you please. You're going to make a copy of it, and you turn in one copy of this at the end of class. I understand with exam 4 that it goes into the office, but I do want you to turn your exam in along with this document. Either in the blue book or on exam 4, I want you to put down your answer on multi-state, right? So I need to see your multi-state answer in the examination. All right, UCC Summary Sheet. Let's go over that kind of quickly here. And I'll point out to you those areas you can circle that I think are particularly important. One in Article 1, I think 304, which is good faith, is important. I think 306 is important. Basically, releasing an agreement without consideration by a written waiver or release. And 308 is important. So, way to utilize your reservation of right. The definitions aren't really important, but you gotta know when something is, or you think something is goods, and when clearly it's land or services. The UCC Statute of Frauds 2-201 is different than the statutory statute of frauds in the PCA. And you need to know when that applies. You need to know about the confirming memos and the specially manufactured goods exception. We talked about 2202, which is the full evidence rule. 2-205, firm offers, I'd circle that. Did a great job on that. Great job on that. At the midterm, just very pleased with that. 2207, you hate it, but you got to know it. So go back and look at all those 2207 cases. 2209 we just discussed. To modify a contract, UCC does not require consideration, but it has to be done in good faith. So, 2209 is important. The warranties, 313, 314, 315 are important. 316 is the exclusion of warranties, but don't forget, if there's an express warranty and a exclusion of that express warranty, it's ineffective. discuss this, but we'll discuss it. 609, right to adequate assurance of performance. If you're not certain, and this is true in common law as well, if you're not certain that the other party is going to perform, you can demand assurance of performance, and if they don't give you adequate assurance of performance, you can treat that as a repudiation or as an anticipatory breach. 610 we just talked about. 615 is the UCC version of impracticability of performance or frustration of purpose. And it's the excuse by failure of the presupposed condition. $708 on remedies is that loss volume sales discussion we had. 712 discusses cover. 715 is important, incidental and consequential damages. And 718, liquidated damages. Might give you a liquidated damages question. All right. So next week, if you have questions, I will answer questions. There won't be anything on the file exam that we haven't discussed tonight. So, yeah. If you have questions, what I hope happens is you study this whole week. Let's do a rough go-over. If you have questions, come in and ask questions. If for some reason you can't be here, you might get somebody else, ask them a question, and I'll answer the question. Please, stop and shout next week.
Are you losing that much water a day?
How much